Hello guys, this is Sanjana Pariyar, an intern at Lexis & Company, and I'm pursuing BLB. This is my first year. Today we'll discuss about sedition. Now sedition laws were enacted in 17th century in England when lawmakers believed that only good opinions of the government should be survived, and as bad opinions were detrimental to the government and monarchy. The law was originally drafted in 1837 by Thomas Macaulay, the British historian politician, but was inexplicably omitted when Indian Penal Code was enacted in 1860. Now, Section 124A was inserted in 1870 by an amendment introduced by Sir James Stephen, when it felt the need for a specific section to deal with the offence. It was one of the many draconian laws enacted to stifle any voices of dissent at that time. Famous sedition trials during freedom movement. Some of the most famous sedition trials of the late 19th and early 20th centuries involved Indian nationalist leaders. The initial cases that invoked the sedition law included numerous prosecutions against the editor of nationalist newspapers. First among them was the trial of Chandra Bose in 1891. Sedition law today. Sedition is a crime under Section 124A in the IPC. Now, what is 124 IPC? It defines sedition as an offence committed by any person by words, either spoken or written, or by signs, or by visible representations, or otherwise, like gestures, bring or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Disaffection includes disloyalty and all feelings of enmity. However, comments without exciting or attempting to excite hatred, contempt, or disaffection will not constitute an offence under the section. Now, what is the punishment of this offence? Sedition is a non-bailable offence. Punishment under section 124A ranges from imprisonment up to 3 years to life term, to which fine may be added. A person charged under this law is barred from the government jobs. They have to live without their passports and must produce themselves in the court at all the times as and when required. Major Supreme Court decisions over this sedition law is Supreme Court highlighted debates over sedition in 1950. In its decision in Birij Bhushan versus the state of Delhi and Ramesh Thapar versus the state of Madras. In these cases, the court held that the law which restricted speech on the grounds that it would disturb public order was unconstitutional. It also held that disturbing the public order will mean nothing less than endangering the foundations of the state and threatening its overthrow. Thus, these decisions prompted the first constitution amendment, where Article 19(2) was rewritten to replace undermining the security of the state with in interest of public order. In 1962, the Supreme Court decided on the constitutionality of Section 124A in Kedarnath Singh versus State of Bihar. In 1995, the Supreme Court in Balwant Singh versus State of Punjab held that mayor's sloganeering, which evoked no public response, did not amount to sedition. Now, there are many arguments in support of Section 124A, where Section 124A of the IPC has its utility in combating anti-national secessionists, and terrorist elements. It protects the elected government from attempts to overthrow the government with violence and illegal means. The continued existence of the government established by the law is an essential condition of the stability of state. If contempt of court invites penal action, contempt of government should also attract punishment. There are many against 124A arguments where Section 124A is a relic of colonial legacy, it is, and unsuited in a democracy. It is a constraint on the legitimate exercise of constitutionally guaranteed freedom of speech and expression. Uh, the British, who introduced sedition to oppress Indians, have themselves abolished the law in their country. There is no reason why India should not abolish this section. Yeah, uh, as I just mentioned, Britishers do not have sedition now. They have like abolished this particular law. The terms used under section 124A, like disaffection and vague and subject to different interpretation to the whims and fancies of the investigation officers. The sedition law is being misused as a tool to persecute political dissent. A wide and concentrated executive discretion is inbuilt into it, which permits the blatant abuse. Now, what's the way forward? India is the largest democracy of world, and the right to free speech and expression is an essential ingredient of the democracy. The expression or thought that is not in consonance with the policy of the government of the day should not be considered as sedition. Section 124A should not be misused as a tool to curb free speech. The Supreme Court caveat given in Kedarnath case on the prosecution under the law can check its misuse. Uh, the higher judiciary should use the supervisory powers of the sensitize and magistracy and the police to constitutional provisions protecting the free speech. Thank you. This was all for today. Do let me know if there's any question related to the content, and I'll get back to you as soon as possible. Like the content. If you like the content, please like the video. And this video does not solicit any kind of promotions or advertisements. This according to the Bar Council of India, and this is for educational purposes only. Thank you.